Please come concisely
Yes.
where you have taken this ground in your writ petition. Please come directly or concisely this ground you have taken in the writ petition and what is the reply of them and how it has been dealt with by the High Court. These things please apply.
Yes, kindly see page number. Page number W. In the list of dates, it's mentioned.
It will not be reputation.
Please, they are unable to understand.
Petition.
That whatever you write in A, B, C, D, W, Z, we are not interested in that. We are interested what grounds you have taken by challenging the violation of this rule. Then what grounds you set out in your writ petition. Please show us that much.
I'm sorry, Lord, writ petition is not on record.
Not on record, then let it say you file it, then we'll consider your case.
I will file it.
देखिए इस पर लिख दीजिए the petitioner counsel prays for time to file the pleadings of the writ petition and the counter affidavit filed by the state of Bihar. Full stop. Need to be done within
Provision may be given to file an joinder also, Lord.
4 weeks. 4 weeks कर दीजिए उसको.
Lord, permission may be given to file an joinder also, Lord.
क्या लिखा? उसको rejoinder की जरूरत नहीं है. उसको ये लिखिए. Counsel for the petitioner prays for time to file rejoinder attaching the pleadings of the writ petition and the counter affidavit and other material documents filed which is not on record in the writ petition.
Online.
Yes, please.
Just a few minutes. That note you wanted, I've updated the note of that can be taken. Give that.
Dated.
Based on this,
Yes.
the first one, your lordships had asked about the syllabus for the TET and what they would go through. So that, if from this same note, my lords, if your lordships come, this is the same. At the first page bottom, last slide.
Yes, please.
Rule 7D and E's pattern of the exam notes, that's at page 27 of the counter.
Yes.
Next page, top, rule 7J, third item, 7J, second page.
Syllabus will be as per schedule.
Schedules 2 and 3, that's at page 28. And the schedules 2 and 3 are at page 32 and page 33 of the counter. This is just to respond to yesterday's question. Today's question, which you put to Ms. Mona.
No, we'll come to that. Is it?
No, I just want to give the citation.
No, we are asking a different.
You are not replying to what he said.
Sorry,
Mr. Gopal Shankar, you are very fast.
No,
We are not that much.
no.
Absolutely fine.
Yes.
This is specified in that rules of the TET,
Yes.
JT, and PAM.
Correct.
Please compare this JT
Yes.
with CTET.
Yes.
CTET,
Yes.
what is prescribed in CTET.
Syllabus.
Yes.
So we can understand the curriculum of CTET and the curriculum of the JTET, that is different curriculum.
So do they have it on right? So the CTET.
So we are not going fast, very.
No,
We
no,
want to understand ourselves.
I will explain. Now the CTET syllabus has not been placed on record. I have it here. It mentions exactly 20 languages, which are the scheduled languages under the Constitution. And it says, select 2 languages in which you appear for CTET. List of languages offered with that codes as follows. This is not on record. I'll place it on record, but this is the CTET, those 20 languages. Under the Jtet, as the lordships have seen yesterday, we pointed out, it's there in these pages itself. Rule 7I, the second entry, just above 7J, page 2 of the note.
We want to see these languages.
Yes.
These rules.
Page 28 of the counter.
Counter दिया जाएगा इनको. In the first case counter,
Yes, sir. First case counter.
we want to look into this
Yes,
because this may have some relevance.
absolutely. I take it.
So we come to rule 7,
Yes.
page number 46.
Yes, that's where it starts.
Page 36, please.
26, bottom is 7, the format of the teacher, your lordship have.
Will be as follows.
Yes, follows. I will read the whole thing because it's relevant.
Please kindly read.
Yes, there will be 2 levels of eligibility test, that is primary school and higher primary level, and the candidates will.
What do you mean by higher primary? Middle.
6 to 8.
6 to 8.
1 to 5 is primary, 6 to 8 is higher.
Online.
So there will be 2 levels, primary and higher primary, and the candidate will be able to appear in both the level examination. Primary is 1 to 5, higher primary is 6 to 8. Each level of examination will have a consolidated question paper, duration of which will be as follows: 2 hours 30 minutes, 3 hours. For visually impaired, additional time of 30 minutes. The exam will be a multiple choice, there will be no negative marking. Pattern of the tests are given, which is this in accordance with the rules. Child development and teaching methods, multiple choice, 20 marks. Language 1, assistant teacher, Hindi and English. For Hindi 20 questions, English 20 questions. Urdu, assistant teacher, Urdu and English. Then language 2, which is regional or tribal language. This has as much as 20 marks, which is regional or tribal language. So it is not the 20 languages which are in the Ctet syllabus. These are separate, it's in the schedule.
There also the test is for all 20 languages?
No, you have to choose 2. You have to choose 2.
Then there also is a choice?
Yes, but because it's Jharkhand, the languages are different, and I'll show you
That will see.
Yes.
Whether the languages are similar.
Your argument we can understand
Yes.
that 2 regional oblique travel language.
Yes.
And what is the wording we have to compare with the CTET to that effect.
That's
So therefore you are asking that much.
that just show me CTET. We're getting printouts of the CTET.
Need, you please give the printout.
I'll give you.
Let me look into.
I'll give you.
CTET is there somewhere, otherwise we'll look into here.
It's not on record, to be fair. I'll give you a lordship's time.
Alright, fine, come to the next.
Then below that note is the pattern of eligibility test for classes 6 to 8, similar in nature. Only that from 20 marks, language 2 becomes 25 marks.
Okay.
That's small Roman 3.
Language is still language 2, regional, tribal language.
It's not right, Sanskrit. So, but
So
earlier,
here it is one added.
yes,
This is Sanskrit.
Sanskrit.
Alright, 2 regional
Yeah.
travel language with Sanskrit.
It's Sanskrit.
So
So,
like 25 marks.
25. Yes.
More like
Then page 28.
28.
The question papers will be in both Hindi and English languages, and the medium of examination will be Hindi or English. The question papers of other language subjects will be in the respective language, if you choose another language.
The question paper of the eligibility and primary school level will be based on the syllabus of 11.
Yes, I'm sorry. It will be based on syllabus of class 11 and 12 under NCERT, CBSE, and syllabus approved by state government. Maximum level of difficulty will be 10 plus 2, higher secondary or equivalent. Questions of eligibility test for higher primary will be based on syllabus of class graduation under syllabus approved by UGC.
That is not relevant.
That's not relevant. Regional and tribal language mentioned under language 2 in rule 7, D and E, which your lordship saw, will be as per schedule 1 of the rules. If I can take your lordship right away to schedule 1, that is
Yes.
page 31.
Page 31.
Yes.
Yes.
Yes, the CPE.
Yes.
District wise list of tribal regional languages under Jharkhand Elementary School Teacher Appointment Rules 2018. Lordship will see against each district the languages are there. Udak and Santali are the most prominent ones, but there are others as well district wise. There's the district wise tribal language and the district wise regional language separately. So the regional language, your lordship can see Nagpuri, Kurmali, etc. Khorda. So all of this is absent in CTET, it doesn't even feature. These are the 24 which are in schedule 1, for which 20 marks weightage in one.
Suppose we look into this rule,
Yes.
then we find
Yes.
that the pattern of the test would be like this. In this pattern,
Yes.
in subjects, this language, regional or tribal language.
Yes.
We accept regional/tribal.
Yes.
So what would be meaning? He may take a regional/tribal, or he is required to opt regional and one driver, it is not clear.
I just see I at page 28.
28.
Back to the rule, no? Rule 7I, where we just departed from, where it referred to languages in Schedule 1. Next sentence. For appointment to the post of teacher, the candidate will have to take the examination in any one of the regional/tribal languages allowed for the district apply. In the regional/
Their applications are also for particular district.
yes, particular district. The Lordship saw yesterday with the advertisement, they had for para teachers, they've given.
That is there.
Yeah,
Whether the advertisement mentions that you are applying for a particular district,
that's so.
or is it general 23,000 posts, so you apply for all of them?
It says so. No.
Is there an option in there that you are applying for district ABCD?
Just give me half a minute, I just have to verify. Just in the mean advertisement. To give you a wrong answer. I just verify
You will come back.
on advertisement.
Suppose we read this,
Yes.
I,
Yes,
we read it simultaneously.
yes,
The intent of rule I is
yes,
the regional and tribal language mentioned in language 2,
yes,
in rule 7, D and E, rule 7, D and E both
yes, that's language too.
will be as per schedule 1.
Yes,
So, what may be a regional or tribal language that would be as per schedule 1. Now, here relevance.
yes,
For appointment to the post of teacher, the candidate will have to take a regional tribal language allowed for the district applied.
correct.
District applied is.
So implication
District applied means
that the application.
you would have applied for a particular district, and in that district,
Yes,
if you applied,
unlimited.
then in the CTET pattern,
Yes,
you must have passed this examination.
correct.
Okay.
It to be done. Yes,
But here there is a difference.
yes,
This rule
yes.
is which rule? This is the
Rule
rule
7, it will be under 7.
This is rule for TET.
Yes, for TP.
Alright, means whatever you are taking in the TET.
Yes,
Alright,
yes,
and as per that TET rules, what is the curriculum and how you have to opt for the languages.
that is correct.
So in that situation, you should have passed it out JTET.
Yes,
So in the JTET mark sheet, can you put an example that in any of the mark sheets for 1 or 2,
yes,
that this is the language which you passed out, and accordingly, this is 1, and the second is
yes,
which we are asking the answer.
yes,
Have you applied
yes,
for the district and your appointment? If we look into,
yes.
alright, this is not the recruitment rules.
No, it's not. It's
This is
the Jtet rules.
Jtet rules. So this is for Jtet means for qualifying the Jtet.
Correct.
Is it any relevance of this
Yes.
in the recruitment rule?
Because statutory is
No, please.
Yes, I'm sorry. Yes.
Please.
Yes.
We have two different things because we are testifying the what proposition in the context of this,
Yes.
the recruitment rules.
Correct.
So in the context of this, is it any something prescribed
Yes.
in the recruitment rules by which they have to apply for the district wise or something? So you have to please compare this and answer.
Very good.
Is it necessary? This is necessary.
Yes,
This appears to be necessary.
yes. So I have extracted for your lordship's convenience in page, sorry. So.
And we are able to convey you.
No, absolutely, Your Lordship must.
We are able to convey you.
So three questions Your Lordships have put to me. I'm just making sure that I've got it right. The first question was with reference to the stipulation in the advertisement that you must apply district-wise. I have to get back to you on that. The second point was, please give an illustration of one.
Not only in the advertisement,
Yes.
it must be supported by proof.
Correct. So that was the third point I was coming to, which you just made. The second point is give an illustration of any one candidate, perhaps the application, which will show that the selection of the language has been district-wise. The third question now is that, is there a reference as far as Jtet is concerned, and particularly district-wise applications in the applicable service rules of 22? Those are three.
Because that is there, every answer would be there. Then Mr. Maninder Singh maybe, it would be a tough question to Mr. Maninder Singh.
But no things, we are having divided burden.
But we have nothing, we are not asking Mr. Maninder Singh.
We had slightly double barrel gun yesterday.
Not doing that.
But Mr. Gopal Shantan,
Yes,
another issue may not be in this case, but just need to understand.
yes,
Now, schedule 1 says tribal, regional.
yes,
Both are different,
yes, there is.
right?
Yes.
Your rule 7 clause I says
One.
that it has to be taken one, either regional or tribal.
Yes, that's my understanding. Yes,
And for the district applied.
yes,
Now, if somebody has taken the regional language,
yes,
he is eligible to apply in that district.
yes.
He doesn't know the tribal language there.
He does.
What is the use of it, his appointment there?
This is a pedagogic question, which is policy wise. Your Lordships are right. This is not a question really I can answer.
But otherwise, the issue is there now.
My understanding is that if you have one or the other, I'm not familiar with Jharkhand. I'm presuming that those who have laid down these stipulations have felt one or the other
We
alternative.
don't accept this argument because the council and Supreme Court are expert of the entire state,
Not me,
entire country.
not me, not me. That may be true of others. I'm an expert in presumption and law.
Presumption.
Right, factors. In fact, Guru knows me very well to know that this is not true about me at all.
No, Guru knows what the other Indian doesn't know. And what would,
Unfortunately, but he will keep it to himself.
yes, please go ahead.
Well, if your Lordship sees, I was just continuing on this, I was at I. In the second part of I, in the regional tribal language test, the candidates will be expected to have knowledge of the concerned language and its grammar, and they can express themselves accurately in that language. The syllabus for primary schools, this is J, and higher primary schools will be as per Schedule 2 and Schedule 3 respectively. I can take your Lordship immediately to Schedule 2, Manoj, which is at page 32.
That is not an issue there.
Not an
The issue is language.
Correct, correct. It is, but
Because other syllabus they may have, whatever is there, we are not going into that detail.
yes, Manoj, but I think just if the Lordship will see it, because it's for eligibility determination based on reference to language, that's what I'm saying.
Well, language is a separate paper altogether.
Correct, correct.
So for that only we are seeing.
Right.
Because you are comparing, this was the argument raised that
Yes,
CTET will not have all these languages,
that is correct.
so they should not be eligible. We have the local languages. Now the question is on that only.
Correct.
You have chosen one regional language.
Yes,
You do not know the tribal language in that area, how you will also be eligible.
but I know one of the two, which are
One of
required.
the two, it's strictly in tribal area.
No, but it's one of the two as prescribed by the state.
That's
As it-
there, but how do they justify this? Your argument is little
No,
dicey on this.
there's a substantial
You
difference
don't,
between.
you don't understand the import of the rule if that is the object.
No, as per their stipulation.
Yes, it is there.
As per their rules, this is the language that they have put. And these, they made it compulsory that you must know these languages and you either 20 marks or 25 marks along with
Yes,
that.
that is.
So, now, the next to pass the examinations, they've given the details, Manoj, minimum 40%.
That's all right, we are not on that.
No, I'm just for completeness reading the entire, that's, now, you have seated printouts? Seated printouts, if I can just hand up, we just got it.
Ctet.
I'll just answer each of these questions that your Lordship put to me, if I can start with seated.
Yes.
Now,
Where is this syllabus in this?
if your Lordship, so please to come to page
No,
4.
this is, no, this is only information bulletin.
Yes,
Not the rules.
no, these are not the rules. No, none of the rules.
These may change from year to year.
No,
This
you
is
don't do
the-
this.
These
Don't
are
do
the.
this, come with rules.
I'll get to the rules.
Don't do this.
I'll get it. Only list of languages. I'll get it.
No, in the meantime, till Mr. Maninder Singh and Guru Krishna.
No, just-
What I will do.
Just
In the meantime, you can find out.
2-3 supplementary points, because
Supplementary
I want them to be put on notice about what we are saying, or I don't want them later to say, in rejoinder, we're bringing up something. That's what, in fairness. So, one is in response to what your lordship asked me about the rules. The page 243, if your lordship will see in the SLP.
242.
Page 243. The rules start at 228.
Yes,
Yes.
243.
This is at the bottom of page 242, last line, says chapter 3, posts and pay scales. 242. The lordship have it?
Post and pay scales.
Yes, posts and pay scales. Now the next sentence, 243. All the posts created district-wise by the state government for smoothly conducting education in primary schools will be under the assistant teacher cadre. That cadre will be district level. It will have the following categories. This is what they say. That will be district level.
Right.
So this is just to respond to that. Now, regarding the one example words of the TET, we have of one
Along with that, in the advertisement, whether the application also invited district-wise.
So did you find that? Application?
Anything mentioned in the advertisement like this?
It's only what we showed your lordships, that the list of
That
district,
is there. It has to be there somewhere that you are applying for district ABCD.
that form we have not annexed was, I'll have
Not
not.
form, it must be there in the advertisement only.
The advertisement has an application form separately, which is not on record. So I have to give you the Ctet rules and the application form. These two things I will have to place before your lordship. Right now, it's not on record. If I may, after the other side finishes, I'll give your lordship that. So this, you've given me copies? Well, this is of one candidate, Vinita Horo. This is from the Jharkhand Academic Council. Has qualified in the teacher eligibility test for the post of assistant teacher held in the month as detailed below. And language 2 is given as Mundari, which is one of the languages in that list. So this is an example as an illustration. This 1 week we have immediately. This
Either
So you want to convey by this,
yes,
as per chapter 3, post and pay scales,
yes,
it recognizes
yes.
the appointment at district level
District
and the influence of this district level appointment
yes.
can be connected with that
Rule 7I and the
7I and J. You want to
That's what I-
convey your content.
That's what I want.
This appears to me.
Yes, that appears to me. Finally, on the law,
And the question still to be answered is,
Ctet.
no,
Yeah, sir.
Ctet is fine, you have to, but my brother has asked,
In the advertisement,
in the
there is a
advertisement,
stipulation.
where
Yes.
there is a stipulation that you should apply
Application.
Ctet.
Yes.
There is that stipulation, or in process of selection, if
Yes.
something had been issued guidelines,
Yes.
thereby in selection, when you will select those persons, then how you will arrange that name of the merit?
Yes.
Would it require to be arranged in accordance with the merit?
Yes.
And if it is so, then how without option can be proceed?
I'll respond to that.
This is first question, then answer.
I'll frame that. Now, if your lordship will just take the compilation of judgments that were handed up to your lordship by Miss Mona.
Yes, ma'am.
Just the first one is Devesh Sharma.
Yes.
Just please come to page 21. This was an SLP arising from a Rajasthan High Court judgment which struck down the NCTE's notification which allowed B.Ed also. They said you can't allow B.Ed also. So para 63, that's page 21. If I may read that. In Society of Unaided Private Schools, this court while upholding the, I'm sorry, Malaj, just in the hand. Yes. This court, while upholding the validity of the RTE Act, held that primary education, which is now part of fundamental right under Part 3, Constitution, has to be a meaningful education and not just a formality. When diploma in elementary education was placed as an essential qualification for teachers in primary school, it was with a purpose, and the purpose was to declare only such teachers as qualified who are trained to impart education to children at primary level. The pedagogy for a child who has just entered the school is an important consideration. A child has come to face a teacher, so to speak, for the first time in a classroom. It is the beginning of a journey for the child student, and therefore, world over, great care is taken in laying down proper foundations in these formative years. Well qualified and trained teacher in elementary school is an extremely vital aspect. A teacher must be trained to teach students at primary level, and this is precisely what the training of DLED does. It trains a person to teach children at primary level. B.Ed is not a higher qualification or a better qualification as is being canvassed in its favor, while comparing it with diploma in elementary education. If your lordship can skip the next few pages which are peculiar to the DLED issue, about 4 lines down on page 22. This defeats the very logic. This is about having a 6-month bridge course along with the B.Ed to bridge it. This defeats the very logic of including B.Ed as a qualification, as the very notification which pushes for the inclusion of B.Ed also recognizes its inherent pedagogical weakness in its relation to primary classes. This is precisely what the High Court has done in this case, saying within 6 months you will have to. It is to cover this defect that all such candidates must undergo a mandatory 6 months bridge course in elementary education, exclamation mark. The irony here is that all this is being done when the state of Rajasthan already has more than the required number of diploma qualified candidates available. This is besides the fact that there is presently no such bridge course available, at least there was none till the disposal of the petition by the Rajasthan High Court. Next paragraph. Under these circumstances, we are unable to comprehend as to what was the pressing need to include B.Ed candidates who are admittedly not fully trained to take up primary classes. Consequently, the decision of the NCTE to include B.Ed for teachers in primary school seems arbitrary, unreasonable, etc. I am adopting this reasoning, my lords, for what the High Court has done. All right. Candidates are available, this will not, but again in that compilation, the last judgment, because I also put a question just now about advertisement being the starting point of the selection process. So the last judgment there is Devin Katti at page 43, my lords. Just see para 11. Para 11. There is yet another aspect of the question where advertisement is issued inviting applications for direct recruitment to a category of posts. And the advertisement expressly states that selection shall be made in accordance with existing rules or government orders, and if it further indicates the extent of reservations in favor of various categories, the selection of candidates in such a case must be made in accordance with the then existing rules and government orders. Candidates who apply and undergo written or verbal test acquire vested rights for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intention. Generally, a candidate has right to be considered in accordance with the terms and conditions set out in the advertisement, as right crystallizes on the date of publication of advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must be held in accordance with the amended rules. Admittedly, the rules are not amended retrospectively, the present. Whether the rules have retrospective effect or not primarily depends upon the language of the rules and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which were in force on the date of advertisement. Now, this has been followed recently, this is a 2-judge decision, no? It's been followed recently, by a 3-judge decision in ASAP Public Service Commission. This is 2020. I'm sorry, we don't,
This is also on record, eh?
no, Malak.
It is there,
ASAP Public-
serial number 2.
Yes, oh, so sorry. You read it? You read it?
Yes, he has already read it.
That's been read. So it's been followed for the same, just paras 15 and 16, if,
Yes, he has already read it.
so it's been followed and that's a consistent position. The date of advertisement, one small thing on facts, the date of the advertisement is 19th July 23. Now the advertisement itself gives for the last date of application 7/9/23 and last date for modification of the application is 15/9/23. Even if we were not to take the date of advertisement as when selection process commences, at least the last date,
Submission of application.
last date of modified application 15 September 23. By then no amended rules had come, impugned judgment had also not come. Impugned judgment, which is in December, becomes the basis for the January new rules coming. So there was no question really of extending a date once the date is over and done and the process is complete in my view. So even if it's not date of advertisement, even a later date, it doesn't come by then and it's not retrospective. I'm grateful.
Thank you. We'll
We'll respond on those 2 points the Lordship mentioned.
find out. Yes, please, Mr. You are for the comment.
For the government in the first matter, not.
First matter.
Not for the
There is a difference in 2 matters.
The state will remain the
There
same.
is, no, difference is only the functioning of 2 engines.
Double engine.
Double engine. You know, we are trying to make ourselves the engine.
No,
of the-
double we are not saying intentionally, 2 engines.
So that,
Well, you can understand, we will not explain why 2.
yes.
And what is the purpose?
But I must confess, Malad, my all colleagues, we sat down together, Malad, to prepare a list of dates, Malad, but even with your lordship.
No consensus.
No. Malad, with your lordships, every question today, I pick up the list and see whether there is a date there or not. And I come to know, Malad, that there are 2 rules, Malad, with which your lordships are dealing. One is the recruitment rule, the other is the TET rule. So, Malad, every time with the help of Malad, my friend and my friend here, we are finding that there are so many notifications in both the rules which have come after filing of counter, etc., or even before that, which are not before
We
you.
are not interested in after filing of.
Only relevant, not only
We are
relevant.
not interested in after filing of the counter. We are only concerned, whatever is prior.
Only on that basis, Malad. No, Malad,
And the another question is, what is the, once rule is there, already there. So where is the import of issuance of notification? Is it circular or it is an amendment in the rules?
there is an amendment in the rules.
In the rules. So prior to that, only relevant,
Malad,
not later.
Malad, I have to first of all answer your lordships on the question which have arisen with regard to section 23 of the Act. If your lordship, if I am able to satisfy on that answer, Malad, then most of the other questions, Malad, in my respectful submission may get answered. Kindly come to 23 straight away.
Incomplete.
Because, Malad, your lordship just keep 2 things in
At
mind.
night.
There
RTA.
RTA.
is a TET rules, Malad, first of all, recruitment and TET.
Whatever you want, we will say.
That, Malad, I am only, my respectful submission, there are 2 rules which are applicable in the court case have some play. One is the recruitment rule, other are the TET rules.
What is to be seen first?
First of all, the Act.
20.
Yes.
So you want to get out this?
No, I want to get into this with clarity, not to myself. I don't want to get out the one.
You are clear.
The one center, the portals of the Supreme Court, we never want to get out. And we have the privilege of this time, we can choose a date of commencement or the last date. Both, Malad. Commencement as well as, kindly come to 23 straight away. Malad, your lordship has seen the,
The application of rules as per your choice.
which Malad will be decided by your lordship.
In the context you ask.
Yes, Malad, in the context, unless the context otherwise required, Malad. Now, Lord, your lordship has seen the definition of school as well as the appropriate government, your lordship.
So by this time, you did 20% rule. Deviated from the thought process which have come from the petitioner side. So 20% rule you have missed.
But with the gravity, you will remind us, no?
Right?
In this situation, this is, we have a sort of arguing the matter, what it's like, so we said, oh, my friend said, oh, you can't get money. Other side, when you open balance sheet, they have so much of fun, what I'm saying is that was before the heritage people.
Now it is plus 10%, 30%.
The rest will be played by Mr. Guru.
All right.
100% flat.
23(1).
Yes.
Qualification for appointment and terms and condition of service of teachers. Well, I am not going to other issues which are not relevant here, about primary education, higher education, central government gets priority under MP 66 not relevant here.
That's not the issue, they have not argued it.
Here, I am not even raising it, this right to education 23(1) and 23(2) and 23(2), my lord, if I am right and persuading your lordship, my lord, the answer is in 23(2), we could resolve a number of issues. Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. No, so far so good, no problem. Kindly come to 2, there are 2 extremely relevant nomenclatures in 23(2). And the relaxation for that vested in the central government is only qua 2, which never includes Stet.
Alright, that is.
Where a state does not have adequate institution. Because, my lord, after the NCTE, it is the approval of the NCTE for all those colleges, my lord, who can legitimately and in a recognized manner grant education in the education courses like DET, etc. So NCTE approves all of them. That is the body created under the NCTE Act. They will not decide what is the, on what parameters a particular institution in part that education will be recognized. Where a state does not have adequate institutions offering courses or training in teacher education, please mark it, TET. 2 things. Offering courses or training. That is neither a course nor a training.
What is neither a course nor a
It
training?
is, I'm going to show to you.
TET you say is not a course?
Only a eligibility test like a CTET. Like a common, it's not yet exactly common interest, the old common interest test, not.
Common interest test is different.
But that is not a qualification or training. It is neither a qualification nor a training. And I will make that good, because it is provided in the rule and there is one judgment of your lordship. Let me repeat this, Lord, I want you to read it with your lordship permission again. Does not have adequate institutions, so this is the legislation.
There are 3 words used.
Yes, Lord.
Adequate institutions offering courses
or
training in teacher education. 2.
Or teacher possessing minimum qualification as laid down under subsection 1 are not available in sufficient number. The central government may, if it deemed necessary by notification, relax the minimum qualification requirement for appointment teacher, but for such period not exceeding 5 years as may be specified in that notification.
This is one of the qualifications prescribed.
One of the qualifications prescribed is not, they are
It is the prescribed qualification or not? Then how do you say it is not a qualification?
I'm no more the qualification in the course. We can understand. One idea of page 11 of the certificate.
So Mr. Maninder Singh, we are not that much, we want to understand the issue. The emphasis is where a state does not have adequate institution offering courses.
Teacher education.
Please. Go separately. Where a state does not have adequate institution offering courses or training in teacher education or teachers possessing minimum qualification as government may take if it deems necessary. So this is all 3 adequate institutions. This is one, here it should be a comma. It should be a comma.
Let us proceed on that basis.
Alright, it should be a comma, then come to the point, offering courses or training in teacher education or teachers possessing minimum qualification. Then as laid down.
May I respond, my lord, straight away?
So this is like this, we have to read like this.
Sir, with utmost respect, there would not be a comma, my lord, with utmost humility. Why? For the reason why.
No, it is just
I'm
for
not,
understanding, nothing, not for humanity or this is not.
I'm responding.
Not like-
I'm responding.
For only interaction.
Yes, for only in that period, my lord, I'm responding. The state is not having something which is that education institution it does not have. Education institution is a common word both for course, that is, state does not have adequate institutions for imparting education or offering courses in the teacher's education, that is number one. Number two,
What in the or is there before that?
I'm answering that now, please read it again. Adequate institutions
Offering
offering
courses,
courses, I stop here,
one,
I stop here.
yes.
And now read it again,
Not and thereafter or is there,
I am coming to that, but just permit.
you are using and,
No, now kindly see the first, I am only categorizing in two. What is the meaning of this?
yes,
State does not have adequate institution is common,
yes,
right, my lord? Adequate institution for what purpose?
yes,
Two different classes. One is offering courses. So state does not have adequate institutions who would offer courses in what? That courses are in the line below teacher education. It's not the science course or a medicine course. It is teacher education.
why the word or is used?
I am coming to that all.
Yes, come to.
Then, Manoj, there are institutions who also offer training. They are not.
Too far-fetched.
No, Manoj, no, kindly, utmost respect, Manoj. The does not have adequate.
You want this section to be rewritten,
No, Manoj, I am not doing that.
language.
I am not doing that at all. I am not doing, I am only saying, Lord, that is not a part of this particular provision. I will show to your lordship how. If your lordship may have, Lord, it is so, Lord, because the scheme, statutory scheme is that which has also stood accepted in the rules. The 2019 TET rules, specific.
All right, we take it as you are saying.
Yes, Lord.
We take as you are saying.
Correct, Lord.
Please go ahead.
Now, Lord,
Please go ahead, I will put a question, then after the.
yes, Lord. Now, what is the sequitur of that is, if a state does not have institutions who can offer courses in the teacher education, number one, or does not possess adequate number of institutions to offer.
Your intent is offer courses or training be read conjointly. Either courses, offer courses or training, then in teacher education.
But teacher education is common.
So teacher education, what do you mean by teacher
In
education?
teacher education, there are offering courses and also for the purpose of teacher education, there is a training separately. So there are institutions who offer.
So this doesn't cover TET. You want to say this?
TET doesn't fall under it.
You want to say
Yes,
that?
that's my respectful submission.
Or we can understand.
Let me repeat for my benefit. Let me
No, no,
repeat.
certainly.
Lord, the first thing is which your lordships have to see is the legislative acceptance that whatever scenario is existing in the country, there are the NCT standard and the BEd courses, the adequate institution, which adequate institution would mean those who are recognized by centralized authority
Yes, that is.
to impart that course or a training. There, if that is the situation, you have to meet the requirement of the state for primary education. So therefore, for a maximum period of 5 years, the relaxation for those conditions can be granted, but that authority is vested in the central government. Now, my respectful submission is, my lord, if you are watching now, that additional document page 11 in the advertisement. Just have a look at that, my lord.
No, we will go to that. Here the complete the rule.
I am only on that. Only on that, and I want to take a stance for that argument. Just keep it with that, section 23, can keep it with page 11 of the additional document where your lordship has seen the advertisement. Page 10, it starts from page 10.
Yes.
This is the notification of 23rd of August 2010, Lord. I'm sorry, Lord, this is not advertisement, this is the NCT rules, Lord, of 20, notification of 23rd of August.
Prescribing qualification.
That is coming to page 35.
I'm coming to that, Lord, yes. Page 10, minimum qualifications. Right, Lord?
Page
Page 10, Lord.
10.
minimum qualification number 1.
Yes.
Then, my lord, your lordship will see small Romanite classes from first to fifth.
Yes.
Now, please see the first A. Senior secondary for or its equivalent with at least 50% marks and 2-year diploma in elementary education, whatever name known. Right, my lord? This is 1. 2. Or. Senior secondary or its equivalent with at least 45% marks and 2-year diploma in elementary education, whatever name known, in accordance with the NCT recognition norm and procedure regulation. So there, my lord, your lordship, appreciate, my lord, the recognition concept by the centralized authority, the regulatory authority, and the institution that is recognized by them. Then, my lord, senior secondary for its equivalent with at least 50% marks and 4-year bachelor of elementary education, senior secondary or its equivalent with at least 50% marks and 2-year diploma in education, special education, and so or is gone. Or is the option in the educational qualification of a course. TET is neither a course nor a training.
Just please.
It is.
Just please. Kindly read the rule again.
Senior second, I'm starting.
Minimum qualification, class 1 to 5.
Classes 1 to 5. Senior secondary or its equivalent, that is 10 plus 2, my lord, with at least 50% marks and 2-year diploma. My lord, your lordship know in education, teachers for education, my lord, they are diplomas and B.Ed. Right, my lord? So one is the diploma, you must have 2 years. First of all, you have 10 plus 2 with 50%. Then you do 2-year diploma. And then, my lord, 2-year diploma. And then second choice is senior secondary, that is 10 plus 2 or its equivalent, with at least 45% marks. Supposing I have received 45% marks, I have not received 50%. And 2-year diploma in elementary in accordance with NCT recognition norm and procedure regulation. Or senior secondary, that is 12 with at least 50% mark and 4 years of bachelor elementary education senior secondary with at least 50% marks and 2-year diploma in education, special education. And then, my lord, if or is gone and comes.
Yes.
And now permit me to read.
Yes.
My lord, 10 plus 2 is an education qualification of a course. The 2-year diploma is a course. TET is a course. This is neither a course nor a training. I read it, my lord. Pass in teacher eligibility test to be conducted by appropriate government in accordance with the guidelines framed by NCTE. And, my lord, now read with this, which is not otherwise the petition in the 2019 rule, which is in the counter affidavit. Just keep both of these documents here. Kindly see Rule 11.
Rule 11.
Rule 11 of the 2019 rules of TET. We start at page 21. There also, we have to update. There are various amendments made.
No, Mr. Maninder Singh, we can understand whether this stand has been taken ever in the High Court. Whatever you are making here.
No,
Or
TET.
petition.
This is not
This
This is not the stand taken.
Let us understand.
Saying where they don't have a case and you have
Mr.
to.
Maninder Singh, we can understand for the purpose of interpretation, something can be done. Or like this one part. But at least you must have come out with a case that please listen. So far as this qualification part is concerned, whichever you are saying, that is not required and their contention relying upon 23 would not be good because of in section 23 it doesn't specify like this. And even then the government is standing like this. We can understand your argument is fine.
I understood your lordship question. Please permit.
That you made the amendment in the rules. You also understood this all is applicable.
No.
No? But
Lord,
for the amendment was required, this is only qualification.
3(2) is to be applied, amendment can't be made by a state government. With utmost respect.
State only made the amendment.
Because we are to amend the trade rules and our recruitment rules.
Alright.
I'll answer it.
Alright, that also will see. But where is that stand in the written statement?
That's what I'm trying to answer your
So
lordship.
you never let the High Court examine any issue?
Your lordships are questions of Lord, state to me which must be answered,
No,
Lord.
we are asking a question. You please go by what is your stand before the High Court.
Lord, I am not.
First stand with it.
Lord, the prayer, the relief.
No, relieve me. Please, what is your stand before the High Court? Come with your WS. But it's written, come with it. Please come, Mr. Marinder Singh, don't go out of there.
I will,
No, we'll not,
I stick to
we'll
the,
take more than that.
Lord, I stick to the pleading.
Please come to the pleading,
Yes.
where this pleading is there.
Yes, let us see, Lord, for that, Lord, I have to show you what is the writ petition, what is the case pleaded. Now, let us see the writ petition, we have a writ petition, show me.
Which page? Which page?
268 in the writ, the SLP paper book.
268.
Arts at 268. Come to please, Malad, your lordship, kindly come to 268.
You never argued all this, the AG conceded, that's all on his section.
Malad, I am duty bound to answer every question of your lordship.
Certainly, sir. Certainly.
The AG statement followed by the subsequent rule is a matter of record, and that
You can't say matter of record.
it's recorded in the judgment.
That's there.
Yes.
But the AG never said so. Despite the reply that they don't have a case, the AG said, all right, we'll consider them eligible.
Kindly see, the prayer is of Ctet,
Yes, yes.
inclusion of that Ctet. Ctet has nothing to do with 23(2). It is not claimed on the basis of 23(2).
That you have not come to that.
But I show you what is the,
We will start that. Please let us understand your pleading.
I see the writ and the foundation first. Let us go to the writ. I will try to find out, Lord, is there any foundation that you have no jurisdiction at all? The
The
other
case initially was not that.
Lord,
The case initially filed before the advertisement.
yes,
It said you are not holding any test.
because Lord, there existed, one is not holding the test because
Yes.
it's not adapted.
And then they said you make them eligible, that's all.
You're not right. 2016, after 2016, unfortunately, state has not carried any test after that. The recruitment which is to take, and your lordship is absolutely right, the writ petition is filed before that. Because till that time, it is only Jtet which was making the candidates eligible.
You did not have hold any recruitments from 16 onwards.
So at 16, nothing has happened, 16 is frozen, Lord, your lordship is right. Both, Lord, for the purpose of recruitment as well as holding of a TET.
All right.
Right, my lord? Your lordship is perfectly right, my lord. When this writ petition is filed, as per the existing rule, there is a condition of Jtet to be possessed by the candidate to become eligible for any recruitment process to be held by the state for teacher. The writ petition is filed first by the candidate who are possessing Ctet. They are not saying that under 23(2), Ctet has to be included because that is the domain of the state. Kindly now see what is the basis of the writ petition. First, one not absolutely right at page 272 that TET is not being held. Now, Lord, kindly see page 275 where reference is made to the TET of 2019. Page number 275, para 2 sub-Roman I, where, my lord, with reliance on rule 12 of TET rule that you will hold the exam annually, is referred to, my lord.
2019, the rules were framed.
Your lordship, which the rules which your lordship has seen in the counter page 21, they are TET rules of 2019.
Right.
In that rules, my lord, Jtet is the TET where clause 12 of the rule says the state will conduct an examination on regular basis annually. That has been referred to, my lord, in subclause Roman 1 of para 2.
Yeah.
It goes up to 276 and refers to rule 12 on the top of the second line. Rule 12 of the aforesaid rules.
Yes.
Malad page 276, second line on top. Rule 12.
Yeah.
Then Malad, your lordship will see that sub-Roman 2, TET has not been held by the respondent, particularly when there is a guideline of NCT conducting teacher eligibility test to conduct a TET in every year. That letter of the NCT is 11 to 11, which is relied upon. Then kindly come to Malad, then your lordship can skip. Yeah, 279 bottom Roman 6.
No, that for last 6 years.
Yes, my lord. And then, my lord, if your lordship may kindly come to the recruitment rules, which is, my lord, referred to in sub-Roman 8 at 281. Which, my lord, these rules are, my lord, here something is relevant, which, my lord, my friend had instructed me to take that as a preliminary submission, but I said, say it must discharge its owner to answer. My lord, 2012 rules were substituted by 2022 rules. Under 2012 rules of recruitment for
There is one question, again, same thing. They filed a petition, pleadings are there, whatever is there before the advertisement. You are contesting that. With reply also, with argument also. All of a sudden a stand is taken that we concede that.
that's, if your
So that means pleading or no pleading, you have conceded everything.
if the state in a given circumstances with the enabling provision and a policy, my lord, is
Not your stand.
I'm on my stand. I'm on my stand of the.
You are standing, that's all right.
My stand.
Your stand is all right.
If my,
But where is your stand in the reply?
I'm not.
Yes.
My respectful submission is this, my lord. NCTE has taken over the field to some extent, the state's autonomy to the extent which is permissible for the primary education is not taken away. NCTE, my lord, is predominance has come. Everybody must follow that, my lord, for complying the scheme.
Standards laid down.
Standard laid down, right, my lord? In that laying down the standard, the central government role for exemption or concession or relaxation is not for any norm of TET. Is not for any norm of TET. It is for the state to decide whether they are permitting Ctet or not.
Please come to here.
So, my lord, is the state.
Let us understand you are coming on the pleadings of the and come to the pleadings of the
Supreme Court as well as not in the High Court do affidavit, original affidavit and then supplement. Yes, my lord, kindly see 281 2022 rules of recruitment. Now, what I was explaining was something important which has not been informed to your lordship. 2012 rules had not provided for any entrance test for teachers by the state. It had not provided. You on your qualification, some kind of a weightage used to be given, and then you would get selected. They challenged Manaka 2022 rule, the same set of petitioners, before the Honorable High Court, that you cannot now convert this 2012 no test to a test now, test for recruitment. They filed a writ petition stood rejected, where they challenged the 2022 rules. And the same advertisement which was put in, both the advertisement is challenged, the rules are challenged. One of the High Court rejected it. 9th of September, where they wanted to rely on this petition, I am informed, I am instructed, I was not appearing. This Honorable Court has dismissed.
Suppose the rules of 52 were challenged. And
the
advertisement vanished.
July 23 and then
So how can challenge? The rules like when it was challenged.
Malad, the rule, the 23, the advertisement is issued.
there was a separate writ for that.
Yes, Malad, by the same set of petitioners.
Maybe of that, I think it's a.
No, I am so Malad, only
I
as a
am
matter.
not making a difference.
Malad, they kindly see the prayer.
We can come to a different point.
I will, yes.
You are saying that 42 rules, along with the July advertisement, it was challenged by the same set of petitioners, and the challenge was to the rules. What were the rules of the challenge in that?
Rule 20, rules of 2020.
You have mentioned so.
that the Supreme Court
Just interfere.
Supreme Court order is on 9th of September.
Oh, that's right, but did
The
you
High
mention?
Court order.
Yes. Did you mention in your counter also
What did mention?
that they filed this writ petition dismissed and the matter is pending before this court?
The High Court order, you must be aware. It's not there in the counter.
Leave aside, if you want to do the same different thing. Writ petition filed challenging the rules of 22. Which rule was under challenge? Number 1.
The entire set of rules are ultra virus.
So entire rules can be
They are incorporated in the order.
No, we can understand what is there.
Let's have a look
But
at
then one thing,
Yes.
and the another is advertisement. So which condition of the advertisement was challenged? And
Meenakshi, what are
and suppose
So they had challenged the entire rules and the entire advertisement on this ground that because the 2012 rules are prevailing, they should get direct appointment. They should not go through this process, which is the subject matter here, saying that they should get direct appointment because they have been waiting.
So, recently they did have to take an examination. So, he doesn't say take the examination.
And
Up to 22 groups, they have to take an examination for appointed. They wanted to overlook the 22 groups to say that the question.
what is the relevance of that even? Maybe that is for rules. At present, 22 rules are in vogue. 22 rules as per 22 rules, whatever is read over, for the purpose of qualification, for the purpose of entrance test, it is not in dispute. So once it is not in dispute, then even they have challenge for that. And whatever the decision is dismissing that petition, what may be a consequence to the present point? There may not be consequence of present point. In seeing, in looking to left, Mr. What is the relevance of this? Mr. Maninder. Mr. Maninder Singh, please.
kindly see, my lord, page 281, I was showing to your lordship the two reference.
Yes, please.
For reference to 2022. Then, my lord, your lordship may kindly come.
Yes.
Para 8, my lord, that the state is not conducting TET after 2016.
All right.
And then, my lord, if your lordships may, in continuation of that, kindly see para 7, 286. 286 para 7. It is relevant to state and submit that the petition number 2 is the mother of one of the aspirant who is willing to participate in the selection process in the state but cannot do so because of the mandatory requirement of Jtet qualification, whose examination has not been conducted in 16. The petition too has come across several number of candidates who possess all the requisite qualification to be a part of selection process, but the state has made Jtet as mandatory. It is not being conducted in the state for last 7 years. And then, already for option, kindly come to the prayer. Page 289.
Page 289.
Last 3 lines, not prayer A. For showing cause respondents, teachers eligibility test examination, the state since the year 2016, in spite of regular demand and protests of large number of affected candidates, which is not only creating chaotic situations of law and order, but also amounting to ruining the aspirations of poor students who are merely aspiring to participate in the process of appointment for the post of teacher, which very much requires a candidate qualified TET as mandated under the provision of the National Council for Teachers Education guideline, as per which such examination to be conducted on yearly basis. But unfortunately, no compliance by the state respondent, gross violation of the guideline of NCTE and the rules of 2019, which are the TET rules, where also the stipulation is contained that we will conduct it regularly.
But if we read this in true sense and spirit,
Yes,
then these petitioners has stated that as per NCTE, under RTE, NCTE is the authority which shall prescribe minimum qualifications for the purpose. They admit this part. TET is mandated under the provisions of the National Council of the Teachers Education Guideline as per which such examination is to be conducted on yearly basis. Like this part they are admitting for the purpose of examination because this relief relates to that holding of that examination, not only
B. For showing for this also how they will address the aspirational large number of candidates available in the state of Jharkhand who have acquired all other requisite qualifications for participating in the process of recruitment of teachers in the state other than having the mandate only because of fault and latches on the part of respondents who have neither conducted the TET examination since 2016 nor have they taken a decision to recognize Ctet qualification.
So here they say recognize Ctet. Now come to next.
For directing the respondent to either conduct the teacher's eligibility test in the light of the Jharkhand teacher's eligibility test examination rule published notification number so and so, which mandates the state authority to conduct the TET examination every year and of the court to consider the Ctet qualification for participating in the selection process of the teachers in the state as per the policy of 2011. Now, Lord, this, if your Lordship may kindly see, there is no argument of any 23(2). The only argument is that the NCT prescribes.
What they are asking there before the report, they are asking that we are aware CTET is not the qualification prescribed for the teachers test in the JTET in the rules of 22. So please, number one, hold the regular test as per 2019 rules. Number two, or CTET may be
Included for eligibility.
included for eligibility.
Correct, Lord.
Now for that purpose, we have to look into what is the answer of the state.
Surely, Lord. But what I am saying, yes, Lord, your Lordship may kindly come to the counter.
Counter.
295.
Yes, please. Please, where we have to look into?
Number 295 it starts.
Yes, please.
Kindly come to 297 bottom paragraph 7. Where Lord the.
You have taken it as a public interest litigation. So you said that the instant public interest litigation was filed for the following reliefs.
Yes.
Alright, then you have referred to the reliefs.
Yes, Lord.
Then you have started answering so and so. That is stated and submitted without para-wise reply.
301, Lord.
Yes.
Kindly see para 10.
No, first 9. You recognize RTA.
No, that RTI nobody can run away. That
We are only referring, Mr. Maninder Singh, they are not saying
yes,
anything.
but RTI
So you want appointment as a teacher in any of the school referred to clause N
yes,
or section 2 of RTA Act,
Lord.
is he or she should possess a teacher's eligibility test,
Yes.
which will be conducted by appropriate government in accordance with the guidelines framed by NCT.
So that is.
So for the answer one part, this is next.
And
Come to 10.
it is stated that therefore the respondent is serious in implementing the provision of RTI in a true spirit and letter for which various consultations are carried out by the respondent with different stakeholders. Better implementation of TET objective after looking to geographical and regional needs and requirements such as various languages, tribal culture, Hindi language speaking, population difficulty before conducting a fresh TET examination in the state of Jharkhand.
Yes.
11. That the COVID-19 Lord, your Lordship can skip.
Alright.
12. So far, TET exam is concerned, central teacher eligibility test is conducted for determining the eligibility of the candidate for post of 1 to 8 in central government schools and other schools which does not fulfill the need and requirement of the state, regional languages and other local needs, and whether to consider CET qualification as equivalent to Jtet in the matter of policy decision. Then, Lord, your Lordship can come to paragraph 15.
Yes.
Respondent in the process to bring necessary amendments in the JTET exam to bring it on the quality and standard of CTET level. It's most humbly submitted that the respondents are going to bring some necessary amendments in the JTET rules which is not.
Rule kindly para 13 is also.
Yes, Lord, 13 I read.
It is most humbly and respectfully submitted.
Respondent said it is in the process of framing a rules for conducting fresh TET examination in the state of Jharkhand, which is under process, and due to which much time has passed for conducting TET examination in the state of Jharkhand.
Then
Lord, 14, once the rules will be framed, it will be sent for cabinet.
Then 15.
15, respondent in the process to bring some necessary amendments in the JTET to bring it on the quality of CET test, and my lord, it's most commonly submitted that the respondent going to bring some necessary amendment which are under process. Stated that the circumstances there are less considered. So, my lord, what the state response?
Solely TET, about TET you are telling.
Only about TET, because the prayer is only for TET. Conduct of TET or CET be permitted.
Eligibility. All right.
It's an eligibility test.
All right, please go ahead, go ahead.
Well, then,
And one thing you admit here, that 15,
yes,
the respondent is under process. Amendment JTT exam to bring it on quality and standard of CTT. That shows that your standard is lower.
what happened is,
That's what you are saying.
the standard of CTET for central schools and other schools
Is higher.
does not necessarily mean whether the standard in the state will be lower. But yes,
This is what you are saying.
it's always an aspiration, Manoj, that you must also be that pedestal where you can say, I am as good as anybody else. But that does not mean, Manoj, that I am not meeting the requirement of minimum.
That you have to accept that somebody is above.
Your stand is, it indicates that further respondent is under process, necessary amendment in JTET exam
Yes, Manoj.
to bring it
Yes, Manoj.
on the quality and standard of CTET level.
Correct, Manoj.
What does it mean?
Manoj, the
Your act and the rules are not at par to the CTET, so you want to brought it to the CTET
Your
level.
Lordship may also read it with para 12, Manoj.
Yes.
Read.
12 is your Lordship may permit.
Yes, read.
That so far as CET exam is concerned, CET test is conducted for determining the eligibility for teachers for classes 1 to 8 in the central government schools such as so and so and other schools, etc., which does not fulfill the needs and requirements of state, regional, language, and other local needs, and whether to consider CET qualification as equivalent to TET in the matter of policy decision, which what is the clause 10 of NCTE. And clause 10 made it only enabling for.
Please go ahead, this is not good. Go ahead.
Clause 10, I have to come.
We'll consider, we are not looking on that. Come, go ahead.
Yes, Manoj. So this is the reply which is given, Manoj.
No, please go further.
Yes.
Further reply.
Para 16.
Yes.
It is submitted that the respondents are going to bring some necessary amendments in the JTT rule which is under process.
So, this is you said, this is misconceived. Then rejoin the affidavit. Third here, about that point, that the CTET must be made applicable or not. You said, clearly said one line, it's a policy decision.
No, I am saying something else, Manoj.
So this is the first counter affidavit.
Yes, Manoj. Of
Which
course.
is another counter affidavit.
Yes, Manoj. Let me show the second counter and then make my submission.
Yes, please.
315.
315, supplementary counter affidavit.
Yes. It starts at not 314. And then Manoj, your Lordship may kindly see. Para 5. At 317.
There is some order of the court.
There was an order of 15/7/25/7.
The petition was
Which
filed.
is that order?
25/7 order.
The import of that also.
25/7. Just, that is what your Lordship seen yesterday that the rate petitions were filed before the adjournment.
No, that's
Right,
right.
one, yes, order of 25/7.
Yes, I'll just give it to your Lordship, know that order.
Where is this order? Page 58 of
The counter affidavit.
Supreme Court counter affidavit. Supreme Court counter affidavit. Supreme Court का counter affidavit.
Page 15, 58, I'm sorry, page 58. Same order where your Lordship has seen that TET rules, same volume. In the course of hearing, at page 58, not if your Lordship have got it.
Yes.
In course of hearing learners in a council, she is so and so appearing for the petitioner in the lead case, would draw the attention of court to clause 10 of the guideline for conducting the which is provided at school. I'm sorry, Lord, your lordship, this is my children. May I read it now?
Yes, please.
In course of hearing learners in a council appearing for the petition, the lead case would draw the attention of the court to clause 10 of the guidelines for conducting TET, wherein it is provided at subclause B that a school referred to in subclause 1 and subclause 2 mentioned herein may also consider eligibility of a candidate who has obtained TET certificate awarded by another state duty with legislature in case a state government duty with legislature decides not to conduct a TET school at 1 and 2 in the state duty would consider the TET conducted by the central government. We are of the opinion the state government is genuinely creating a number of posts for the state TET examination required to be conducted, which has not been held at least for last 9 years. The examination was held in 16. Then it should take into consideration the said provision. We advise the state to file a short affidavit stating whether they intend to allow these candidates who have obtained TET certificate from the central government.
Now read your counter.
Yes, now kindly see come to para 5, 317. 317, para 5.
Yes, please.
The reference is made to this order, so your lordship can skip para 5, para 6. It is subjected that before going into the query, it is necessary to bring a factual aspect for proper adjudication. One of the essential qualifications of person to be appointed teacher is referred to in so and so. He is RT active that he should pass the eligibility test of TET, which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. It is stated and submitted that state of Jharkhand is intending to implement the Jharkhand TET objective geographical same thing wrote with regional needs requirements such as various languages, tribal languages, culture and Hindi language speaking population within the state of Jharkhand. It is most humbly submitted that the central teacher eligibility test after effort is basically concerned is conducted for determining the eligibility of candidate for teacher post class 1 to 8 in the central government school such as NVS and KVS and others too. It is stated that the state of Jharkhand has formulated its own teachers eligibility test rules of 2019, dated 2019, which apart from math, science, social studies, teacher stipulation for language teacher, further prescribed for eligibility of teacher imparting education of regional language, other local tribal languages for the preservation of culture, needs and diversity of the state. It is stated that Jharkhand Teachers Eligibility Test Rule 19 prescribe for different eligibility criteria with respect to appointment of language teachers who are required to have qualification. At least one local language out of various local and tribal languages spoken in the state. That also, my lord, would answer your lordship. One, either the regional or tribal, my lord.
That's the rules.
Yes, that is stated that Jharkhand Council of Education, Research and Training, Ranchi, is responsible for performing the important function of promotion of education research, improvement of educational technique, practices and such, finding, development, curriculum, instructional and exemplar material, method of teaching, techniques of evaluation, teaching data. It is stated that the Jharkhand Council of Education, Research and Training, apart from aforesaid activities, publish and distribute books for regional and tribal languages free of cost, etc. Further stated that there are enough numbers of JTT qualified candidates within the state and hence allowing CTT qualified teachers in the vacancies of the state run school based on prejudice. Stated that there can be no doubt about the fact that the ultimate beneficiaries of the recruitment process would be a large number of children within the state who would suffer if there is undue delay in the appointment of teacher. However, the state is at liberty to set the qualification, particularly when these qualifications are in accordance with the statutory guidelines framed by NCT. Please mark this sentence, Lord, that it would be for the state to decide which Lord test is to be permitted, because that is the domain of the state, and that is also Lord recognized and acknowledged in the NCT guidelines. It is further stated that petitions contain and place reliance on clause 10B of the guideline for conducting teacher eligibility test, which provide that TET conducted by state government with legislature shall apply to a school.
You complete this directly.
Yes. School of the state government duty with legislature and local authority referred to in subclause 1 of clause N of section 2 and a school referred to in subclause 1 of clause N of section 2 of RTI. The guidelines further provide that a school at 1 or 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state duty with legislature. In case a state duty with legislature decide not to conduct a test, a school at 1 and 2 in the state duty would consider a test conducted by the state government. That it is further stated, central TET qualified candidate qualifying TET by another state can only be considered for a state-run school when the particular state government has decided not to conduct its own test. Submitted that it's not the case of the state government has decided not to conduct the JTET, and these circumstances, state government is not bound to consider central TET or a candidate qualifying TET by another state UT as eligible qualification. The CT qualified candidate can be made eligible in a given contingency where the state government is not conducting TET. But when the contingency does not exist, there is no occasion to make central TET candidate eligible or to allow those candidates who obtain TET certificate from central government or any other state. This is not submitted that there has been certain contingency due to which regular JT examination could not be conducted regularly, and hence the state is intending to allow age relaxation to the candidate for upcoming vacancies. Moreover, it is also intended to conduct JT examination before start of fresh recruitment of teachers within the state. Stated that issue whether to consider CET or PET from is a matter of policy decision of the state government. I have read and understood, so but that is.
But before this date, the advertisement had been issued.
Before this date of filing this affidavit, this.
So this is 14th August.
14th of August.
July advertisement was there.
Advertisement is issued on 9th of July.
July.
Yes, your lordship is right. I'll come, lordship.
We'll come back. Feedback.
Yes.